Hi, I'm Emily and I am here with Maya Murphy's attorney, Lauren McDonald. Attorney McDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My questions today for Attorney McDonald are, can my child be subject to random drug testing in school? And can my child's school use metal detectors and/or sniffer drugs to conduct these searches?
Drug testing is considered to be a type of search. For that reason, school officials may require your child to take a drug test when it is justifiable and the requisite reasonable suspicion standard is met. There are, however, in this context, certain exceptions to the reasonable suspicion standard, whereby your child may be subject to drug testing regardless of whether or not they are suspected of taking illicit drugs. The United States Supreme Court has found that random drug testing of athletes through urinalysis is not a violation of a child's Fourth Amendment rights. The court articulated a three-part balancing test that is to be used when evaluating suspicionless searches, consisting of 1, the nature of the privacy interest upon which the search intrudes, 2, the character of the intrusion, and 3, the nature and immediacy of the governmental concern and the efficacy of the means to meet it. Your child's right to privacy in the school is distinct from that of the general population. This lessened right to privacy is even more pronounced for student athletes, due in part to the voluntary nature of the child's participation and the reduced expectation of privacy. For example, communal showers and shared locker rooms. The Supreme Court has extended this decision in a subsequent case, which now allows schools to drug test any students who participate in extracurricular activities, such as the academic team, cheerleading team, the band, and choir. Even school-sponsored proms and dances can be considered extracurricular activities. Further, the urinalysis test is designed to detect only the use of illegal drugs, such as amphetamines, marijuana, cocaine, and opiates, and not for medical conditions or the presence of authorized prescription medication. The circumstances surrounding a urinalysis test are no different than going to the restroom in a public facility, and a monitor is present only to make sure that your child does not tamper with the urine specimen. The procedure used to conduct a urinalysis test has been found to not be intrusive of your child's expectation of privacy. Drug tests are considered a reasonable means of preventing and deterring student drug use in a manner that does not violate the Fourth Amendment. Your child's school has a compelling and judicially approved interest to deter, detect, and prevent the use of drugs in their school in order to preserve the safety of the school environment. The results of your child's drug tests are confidential, and only school personnel who are on a need-to-know basis will be granted access to the records. Additionally, these tests may not be turned over to law enforcement officials or used to discipline your child. They are employed solely to identify if your child may have a drug problem and accordingly needs help. As a result, schools, at their discretion, may implement suspicionless drug testing programs that your child must adhere to if they plan on participating in school sports or extracurricular activities. Due to increasing violence in schools over the past 2 decades, school districts have been permitted to employ metal detectors to screen students for weapons or other contraband that may harm the student population. A metal detector, whether it be stationary or handheld, is considered to be a minimally intrusive search. The courts have allowed schools to use this method in order to ensure weapons are excluded from the school environment. In regards to the use of sniffer dogs, it is generally seen as being non-intrusive, since sniffer dogs are exploring for items that, while perhaps are not in plain sight, are within plain smell. In accordance with the Connecticut General Statutes, if a sniffer dog alerts to a certain smell within your child's locker or other school property that has been made available to them, it will likely satisfy the reasonable under all the circumstances requirement and school personnel may conduct a search of your child's locker or other property. Note, however, sniffer dogs may not be used to search your child's person unless the reasonable suspicion requirement is satisfied. Although metal detectors and sniffer dogs are usually found to be minimally intrusive, your child's school district must still have a reasonable suspicion to conduct an additional search of your child or their property. If one of these devices alerts school personnel of possible contraband, a search should not continue unless school personnel can show that it was reasonable for them to conduct a more detailed search at that time in order to obtain evidence that your child violated school policy or the law. If you have any questions about your child's Fourth Amendment rights in the school setting, please give me a call and I'd be happy to discuss.
Attorney McDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney McDonald at lmcdonald@mylaw.com, and please visit mylaw.com for more information.